everyone, and welcome back to Ask Prashanthi. I'm your host, Prashanthi Reddy. I'm an immigration attorney and I'm dedicated to helping you navigate those sometimes challenging and often complex questions with reference to immigration law. In this show, we tackle all your questions, those pressing concerns that you have about your visas, green card, citizenship, and everything else in between. We pull questions from all our channels, from YouTube, LinkedIn, Facebook, Instagram, and of course, those excellent submissions that you send on our website. So if you have a burning question, be sure to submit it and I will answer it in the next episode. So let's look into the first question. This is from Safran Khan and it was posted on my YouTube channel. And the question is, I'm waiting for the F1 sibling visa category outside the USA. Should I follow the dates for filing chart? So this person is waiting for the sibling green card category. We know it's a long wait. So we know there are two tables on the visa bulletin. One is dates for filing and the other is final action date. So to answer your question, Safran, you have to follow the final action date table because even though USCIS has said that for this month, dates for filing table can be used, but that's only for people who are in the US, not for people who are outside the US. If you're outside the US, you always have to follow only one table, which is the final action date table. I hope that's clear. So if you come in on a visitor's visa or you come in on a H1 or some other non-immigrant visa, then of course you could follow the dates for filing chart when USCIS says that you can. The next question is from Guru, and this was also submitted on my website. If a candidate who filed a change of status from H1 to B2 within the unemployment grace period of 60 days received a job offer with B2 application while the B2 application is not yet approved, can he then file for the H1B transfer? Can he go through the process of filing H1B transfer on a premium process basis and get approval, or does he have to go through consular processing in India? This is a great question. So the scenario is that change of status has been filed from H1 to B2, maybe because the person has lost their job or has decided to change their job and has resigned. Then within the 60 days grace period, they filed, as I said, the B2, which they're allowed to do. Now they find that they got another job, but the B2 is not yet approved because, as we know, the B2 processing takes 4 to 6 months by itself, or sometimes even longer, and there's no premium processing. So you might find yourself in a similar situation where you filed for the change of status, but now you have a job, but you don't have an I-94, you only have a pending B2 status. In this case, you can file for a change of status again from a pending B2 to a H1. It's called a bridge petition. USCIS has said in the past that they will honor these petitions, but in case they don't, and if you do get an RFE, because it is a case-by-case decision, then they might ask for the B2 approval. They will give you 87 days to respond. If you don't get the B2 approval, even within that time period given, then they might approve then they'll approve the case for the H1 that you're filing for consular processing, in which case you'll have to leave the country and you can come back um, if you have a visa in your passport. If you don't have a visa, then you'll have to go to the consulate and get a visa. I hope that answers your question. The next question is from Mastan, and it was also submitted on my website. And he asks, as a green card holder, can I file for a green card for my future spouse who's currently on a visitor's visa after we get married? So basically, he's saying that his spouse, once she becomes his spouse, will be on a visitor's visa. So can he file? Yes, you can, because she has to be in status so because you are a permanent resident. And the other thing to remember is your priority date has to be available. Because if you file The I-130, because you won't be able to file the 485 if your priority date is not available. You'll only be filing the I-130. And the I-130 doesn't give status. So the person will then, your spouse will have to, you can file the I-130 because she's presently in status, she's on a B2, but your spouse will have to continue to maintain her status by changing status or filing for an extension, whatever it might be, until the priority date becomes available and you're able to file the 485. So that might be challenging because it might take some time for the priority date to become available. So from that point of view, be careful um, if you do that. Of course, if the priority dates are available, even if it's just the dates for filing table that's available, then of course you can file the 485 and she gets status pending 485 status. So she doesn't have to worry about extending her visitor's visa. You also have to remember another thing. There's an issue of intent. If a person is traveling on a visitor's visa, comes in on a visitor's visa, and then immediately gets married to a US citizen and then files, there might be an intent issue. The USCIS might say that um, it was not a proper entry because she intended to immigrate at the time that she was arriving on a B2. So in order to avoid that, I would wait for some time, maybe 90 days or so, um, so that before filing the adjustment of status, so that USCIS can still ask that question, but maybe they won't if you wait for some time and then file for adjustment. So the two issues to remember is visa number availability and filing, make sure you file after at least 90 days. I hope that answers your question. Now the next question we have is from Sindhu, and this was submitted also on my website. I am on a H4 visa and it expired on March 29, 2025. I have applied for both H4 EAD extension as well as the I-94 extension, as both have expired. They are both pending. Since I already applied for an EAD extension before it expired, am I eligible to work before renewal? So in normal circumstances, if it was just an EAD extension, then yes, you have that grace period of 540 days, or you have that automatic extension of 540 days. But since your I-94 has expired, one of the preconditions for getting the 540 days is that you have to have a valid I-94. And USCIS says that clearly on their website. They say that for a H4, an unexpired Form I-94 indicating H4 status um, must accompany the Form I-797C, which is the EAD form. It also says that to calculate the new expiration date, you have to add the 540 days to the EAD card expiration date and then compare the 540 days auto extension date to the Form I-94 end date. And whichever date is earlier, that's your new EAD expiration date. So they are looking at the I-94 end date. So if the I-94 has already ended, it means pretty much that you will not get any automatic extension on your EAD. Of course, if your I-94 uh, gets approved before your EAD, uh, gets approved, then you can then get an automatic extension at that point of time. I hope that answers your question. Let's go to the next question, which is from Krishna, and this was also submitted on my website. Can I apply for EB5 green card while in my current H1 status? Yes, you can, and a lot of people do. Because if you're just on a H1, then you might just qualify for EB2 or EB3, and we know the backlogs, especially if you're an Indian national, for EB2 and EB3, it can take several years. So people do apply for the investor visa while they're on H1, which is great because they're maintaining their status, because filing an EB5 and getting an approval takes about 4 to 5 years. Of course, once you get the temporary green card, then you don't have to maintain H1 status. Until then, you have to maintain a non-immigrant status, because getting the initial application EB5 approval itself is taking a long, long time. So it's ideal for people who are already in a non-immigrant status. Some of the eligibility criteria for EB5. EB5 requires that the investor make a significant capital investment in a new US commercial enterprise create at least 10 full-time jobs, um, show proof of the legal source and path of funds as to where they got the money from. Investment must be in a lawful, for profit business, and investor must be actively involved in the management of the business. The minimum investment amount is currently 1.8 million or 900,000 if investing in a targeted employment area, which is basically an area which has a lower employment. So I hope I answered that question and I hope it's clear. So go ahead and apply for that AB5. Just be aware that processing time is really long. And the amount of investment has gone up from 500,000 to 900,000 and 1 million to 1.8 million. And with that, that brings us to the end of another episode of Ask Prashanthi. I really hope that the questions we answered today help shed some light on your immigration journey. Remember, understanding your options is the first step, and then reliable information is the next. So I hope I was able to provide you with that reliable information. So if you have a question you want answered on the show, don't hesitate to reach out. You can leave a comment right here on YouTube, connect with me on LinkedIn or Facebook, or submit a question directly on the website. Please follow the link in the description. Thank you very much and see you again next week. Bye bye.